Kotari? Rosa?
Good morning, Your Honor. Attorney Kevin Basanti, 71061. We have the Courtroom advancement to my right decision in the record. That's in Courtroom. Your Honor, I was just retained on this particular matter last night, Judge, so it's really needed discovery. I was hoping, Judge, for the date of September 26th.
Okay, did I let him pick a day? I did. Okay, go ahead.
Basically, the court has been given. I'm in trial the entire week at the Third Circuit Court from the 16th to the 19th. Judge.
Gotcha. Okay. All right. I've signed, first of all, so that we have everything in order. I've signed the substitution of attorney counsel so that you'll know that. All right. And then I will adjourn preliminary examination, or not preliminary, but the PCC in this matter. I will adjourn it to 26, you said, correct?
That's correct.
All right. Probable cause September 26, 2024, 9 a.m. Bond in this matter will continue.
That's one issue I'm very quickly.
He's asking for a lot. No, go ahead.
So, because my client is on a child, I know the complainant in this particular case is the children of his, the mother of his children. Yes, but he would have absolutely no contact with her. I understand the purpose of the monitor to him. Judge, but he would have no contact with the complainant. They do share children in common, but they do have a family court order that kind of dictates the custody. And so there should be no other issue for having contact with her other than children.
Can I ask this, and I'll hear from the prosecutor in a moment, but I see that the first charge is home invasion. I understand they have children together. Do they live together normally? Okay. Go ahead.
Rather, this is a case where the defendant showed up, forced his way in, and assaulted the victim by twisting her arm and pushing her. He would not leave it, so the victim ended up leaving instead. I am concerned. He did not have permission to enter the home. To my understanding, I don't even know that he had permission to be at the residence at that time. I do not think that it's appropriate to remove this other fiat for 50,000 cash or surety. I believe he was given 5,000 in this case.
And so he is on a $5,000 personal bond. There's been no bond violation whatsoever. There will be no contact.
Let me ask this, counsel. And I just want to make sure I'm clear. Are you indicating that the tether is interfering with his parenting? Or
not so much with the parenting, it's more so with the employment. And so that's why I was asking for a removal of the tether test. But the parenting is still governed by a family court order that we have in custody.
Okay, so what's the problem with his employment in the tether?
So, Judge, my only issue with that is yes, he can cover it up with his pants leg, but there are times where he can't. There's times where it's still visible, Judge. And I'm not saying that he's necessarily in risk of losing his appointment, Judge, but it could be that particular point. And so I'm just asking if the tether can be removed. He knows that if he was to violate his bond in any way, shape, or form, there's no surprise in this case, no Washington County jail. So I think, he knows that no contact until arrival on the bond position that he's done since.
Given the nature of what is at least alleged here, this is an exclusion zone tether, so it doesn't restrict his ability to travel, only excludes him from the place which presumably is the place of this offense, or at least one of the offenses. For those reasons, I think that the tether in this instance is appropriate. I'll deny the motion for bond modification. All right, thank you.
Court does call the case. People versus Sonia McLean.
You got it? We clear in? On the, yeah, okay. All right.
You said, in first,
Oh, hi. Sorry. Are you working?
Yes. All right. All discovery is complete.
That's the mission. May we
This is B3.
There's no need to approach, Mr. Brown wants to approach you kind of, Mr. Brown has asked me, a couple times for any videos in this case. I've sent, multiple emails to YPD requesting any audio or video. They've probably unresponded to. So there may or may, I don't know if there is any video or not, but my requests for any video have gone unanswered. I have no issue with setting it for a PE. If something turns up, we'll cross that bridge when we get there.
You can dismiss it. Well, I realize is there a reason to believe that there is video?
Yeah.
Okay, and the people you requested, Mr. Brown, people have requested a YPD, and they just have not.
They're ignoring it. I'm used to that, but.
I guess, Mr. Childers, to the extent that they're not, there's no response. Is that?
The response is not that there is no video, there's just no response.
Then if
I suppose if the court wishes, I could elevate my email to see if I email command staff, if they may respond, I don't know. It's certainly worth a shot. If we want, in an effort to keep the case moving along, I can stay out until the end of September, and I can keep my efforts.
well, I don't know why it's one thing if there's an issue getting discovery. This is a whole other realm where they're not responding to a legitimate discovery request. And I'm not trying to disparage any department, but the last time I ran into this was with YPD. And I ultimately ended up dismissing the case. All right, here's what we'll do. She wants to say something with her law degree.
Yeah.
I don't think she does. The people around you are doing just fine. Okay. So here's what I'm going to do. I'm going to set so as not to impact the defendant's rights. I'm going to set the preliminary examination. Mr. Brown, prepare an order for my signature that directs that YPD is to turn over all video. I will set this examination for the 17th. Today's the 4th. So I'm going to need it right away so that there's time. But that they're to turn over all video to the Washington County Prosecutor's Office by the 11th. And if they then, that will go under my signature. That way, if they then fail to do what I'm ordering them to do, then the court will take appropriate remedies.
Your Honor, from a logistical standpoint, once that order is signed, would you like for me to send that order along to YPD?
Yes, please. Preliminary examination in this matter will indicate discovery is not complete. But preliminary examination in this matter will be set in person September 17th, 2024, 9 a.m. That will be before me. And then the bond will continue. Now, given all of that, ma'am, is there something you wanted to say?
She was trying to leave and go to the, get on the bus, and there was some contact, so we had to contact Pittsfield Police to make a narrative report that she was not in violation of any court orders. I have a copy of it if you'd like.
Hold on,
Just like to be able to get on the bus.
hold on. You gotta catch me up because that was today.
No, that was the last time.
22nd.
22nd.
Mrs. Morgan approached.
Just hold on. Okay, you're good.
You don't have
So, well, I just want to make sure I'm clear. You got on the bus. You were, okay, but in any event, you ended up on the bus, right? All right.
Because Ms.
Hey,
Morgan,
but hold it, just hold it. Just hold on a moment, okay? And then at some point, the alleged victim in this case came into contact with her.
Yes.
As I'm to understand, based upon what you said, Mr. Brown, she then contacts the police.
She comes back here, asks for my advice. So
Got it. That's it. I don't want to know what you two discuss. But out of that, there then is generated a report from Pittsfield.
yes,
Got it. And so your concern, ma'am, is that somehow the court may try to hold you responsible for that conduct. Okay, I have not seen the report. I do not think that I need to see it. Okay. I'm going to make a presumption as to the advice that Mr. Brown gave you. I think that was absolutely appropriate advice. And should the issue arise, then I would review that report and I would take that all into consideration. All right. But at this point, I am not going to do anything. I don't have a complaint that you've done anything. And so I'm not going to make one. Fair enough?
I need time to get on the bus again. Not leave out the courtroom and get.
Okay. All right. Listen, just listen. Mr. Brown gave you advice, okay, regarding a situation that you had, I guess, last time that you were here, right? So it would seem to me, would it not, that should you leave and that same or similar type of thing happen, that you would then follow the advice that your attorney gave you? And I kind of indicated to you at this point how I'm looking at it. Okay? I know it may worry you, but I think follow what your attorney is telling you. All right? Okay, anything else you want to yell at me about? Not what?
I don't want to have the same issue that happened last time I was here. And you asked Ms. Morgan to sit and wait for it. No.
Okay, hold on. Where is Miss Morgan here? Okay, you need to sit down. No. All right. So you need to get on the bus. Okay, stop for a moment. Miss Morgan, do you need to get on the bus?
Yeah, the bus have video, did nothing happen, I got off the bus.
Okay,
The bus has video, she's lying.
And I'm going to presume you both take the same bus.
I don't have a
Okay. I wish you would stop yelling up here at me. Mr. Feaster? I'm not going to ask you to drive anybody, so don't tell me. I'm just, so, okay, here's the thing I do not know. And I'm going to maybe potentially embarrass myself. I have not taken a bus.
Shame on you.
Well, no, I don't, wow. But I just haven't. And so I know that when I get on a bus or when I did, but it is just so long, the dinosaur was pulling it. But anyway, it just took me downtown and I had to find another bus. And I just told myself I'm not doing all that. So that's why it's my limitation. How often do the buses come to where you would have to pick the bus up, get the bus?
Every 15 minutes across the street.
Every 15 minutes across the street. Okay, so here's what we're gonna do. Okay? This time around, you get the first 15 minutes. Remind me the next time, then you'll get the first 15 minutes, and then you gotta wait and take the next bus. Huh? Oh, so now you took up all my time, now you wanna leave? No, go, just go. That's what we're gonna do. You go, don't get up, Miss Morgan, do not get on that same bus. Do not get on that. That's fine. I don't want you both on that same bus.
Still approaching me and sending threats to me, Your Honor, and that is the process.
Then you report that to the prosecutor's office. They will raise.
I told him again.
Don't know how to change it, right? Okay, so I will just say this, Ms. Morgan, when it is raised before me in a proper way by the people, I will deal with it, much like I said I would deal with her issue. But right now, I want you to take the next bus. The next time around, you'll get the first shot at the bus. She'll wait. Thank you.